SJC-11477, Auto Flat Car Crushers, Inc., v. Hanover Insurance Company.
Let's proceed, please.
Good morning, Mr. Chief Justice, members of the court. My name is Don Jernberg. I'm joined at my council table with Mr. John McMaster.
I will just say, for starters, that you win the prize for having the most interesting named client of anybody today. It's Auto.
The client's here, and I'm sure he appreciates that recognition, Your Honor.
Though it sounds like it's a wrestler.
There may be value in the name of the company, that's true. What we're here today, Your Honor, is to address some issues that were raised in terms of whether or not this case would go forward or not. And the fundamental issue, excuse me, in the case, and our position on that fundamental issue is that damages which have been described as historical, which I'll deal with, are properly used for determining breach of contract in this case, are appropriate to serve the purposes of 93A. They're appropriate to use those damages to safeguard the safe harbor provision that's in 93A, and that using those damages will make.
So what do you say the damages are here? I mean, you got paid in full, right? Hanover came in and paid your defense costs, right?
I don't think they paid all of those. In the underlying case, yes, Your Honor.
Right, yeah. And they paid, they indemnified you, right?
In litigation.
Yeah, they indemnified you for the liability, paid your defense costs. So what do you say the damages are?
Our damages for the purposes of going forward, and we did file a motion for summary judgment and specified our damages, or I believe in that motion, $360,000.
Well,
Consisting of?
And the amount, because our position, Your Honor, is the payment does not erase the fact of damages. What payment does is decide whether or not.
Well, you sued Hanover, saying you need to defend us, right?
Yes.
You have an obligation to defend us under the insurance contract.
Correct.
And you won. And they said, okay, here's all the money for the defense, and oh, by the way, we're going to indemnify you as well for any liability you have. So the $360,000 is what?
Paid amounts that my client incurred. They were reimbursed. But here's the critical
I'm
part.
sorry, paid for what, though?
Paid for what?
Paid for defense costs or paid for all costs?
They paid for the defense cost and they paid for the remediation cost.
So the 360 includes remediation,
Yes.
even though there was no finding as to a duty to indemnify?
There had not been at that point in time.
At what point in time did Hanover start paying defense costs?
After we filed our 93A action.
And so what were the attorney's fees up to that point in time?
The attorney's fees in the underlying case,
Yeah.
not in the coverage case, but in the.
dealing with DEP.
With the EPA. Those were fixed. That was done in 2004, and there were some lingering cases.
You got the attorney's fees for dealing with the EPA, and you got the attorney's fees, I take it, for the piece of this action that was litigating the duty to defend, did you?
We did not get all those attorney's fees, Your Honor.
Not for the duty to defend, you didn't?
No, we did not.
Because I thought that $20,000 was really post Judge
All
Garsh's
of those were
decision.
not paid. There were some that were not paid.
Okay, but by her, I mean, did she discount your bill? Because she gave an award, didn't she?
She did not. Judge
Well, I
Garsh
thought
did
I
not.
saw it in the docket entry that she did something about,
No, she did not award attorney's fees, Your Honor.
Well, I thought well, wait a second. I thought she allowed your motion requiring Hanover to defend you, no?
Yes.
So she required Hanover to defend you, but that didn't include paying your defense costs?
The attorney's fees?
Yeah.
Yes.
No, and I'm not quite sure why she denied that motion, quite frankly, but she did deny the motion.
For attorney's fees, for establishing your right to the defense?
Yes.
Can I just get the chronology here? You lost, the defendant lost the summary judgment, partial summary judgment motion on duty to defend in December of 2009. You amended the complaint to add a 93A count in March of 2010. The defendant answered that in April, but did not make a reasonable offer of settlement at the time.
There was no offer at all. Your
And it wasn't until May or beginning in May or roughly then in 2010 that they began to pay in connection with the duty to defend. Is that right?
That's absolutely correct.
And they
Would it
pay-
have made a difference if they had tendered payment before you amended the complaint? There was like a 5 or 6 month period of time. Well, you amended the complaint in March. If between December 8th, 09 and the time you amended the complaint in March, if they had simply tendered payment in connection with the duty to defend, does that change the analysis?
I think that would have changed the analysis because part of what's involved here is maintaining the sanctity and the importance and the deterrent effect of 93A.
Isn't,
That's
but,
critical.
that would have, seems to me that would be sort of like answering with it like a single liability, right? If they'd paid at the time, if they'd done that before. I mean, 93A recognizes that if you pay the money.
If you paid the money, correct.
Right. But could I just ask you this question? I mean, as a practical matter, isn't it the case that really what's still at stake is your ability to argue that the conduct of Hanover was knowing or willful? In other words, if there's no knowing, you gotta litigate it. But if there's no finding of knowing or willful conduct on the part of Hanover, you have in fact been made whole.
Absolutely correct, Your Honor.
So, and it's really that. But the other thing I just wanted to ask you about is this. You talk a lot about you can use the defense costs, et cetera, for the cleanup as the breach of contract damages. And then you go to that second sentence of the particular part of 93A you're talking about that talks about for purposes of doubling or we'll use the judgment in the underlying thing. We don't have a judgment here. So, right? There's no final judgment in this case yet, as far as I can tell from the docket.
Correct, and that's one of the issues we have before this court.
Right.
Is can we overturn, we ask that Judge Donovan's ruling be overturned so that we can get that judgment for purposes of clarity.
Here's the thing, though. It seems to me you don't need that because of just taking your, at least as I understand your argument, you analogize this to Ameripride, correct?
Correct.
There was no judgment there. What the court did was say the damages, it was using the first part of that sentence
Correct.
in 93A11. The damages are X. We double them. We don't have a judgment yet. We double them, and then we subtract the offsets.
Correct.
So you don't, I guess, here's where I'm getting to it in a very lengthy, long-winded way of saying it. I don't see why the sentence in 93A11, fourth paragraph, or wherever it is, about the judgment has any application to your case at all, and you don't need it.
I believe you're correct. We could go forward without it, okay, on the same basis. I mean, this court has said in the ZVI drywall case, okay, you don't necessarily need a judgment in that case either. The one reason, because we're issues of policy here, my only point there would be there may be a reason to use those historic damages to allow the judgment in the underlying breach of contract case.
But you're not going to get a separate judgment. It's always going to be one judgment in this case.
From this point forward.
Well, for forever. I mean, you don't have a final judgment here. You've got a order granting partial summary judgment on the contract claim and on the duty to indemnify claim. That's what you've got.
Correct.
Partial summary judgments. You do not have a final judgment yet.
Correct. Now, and that's because Judge Donovan allowed their summary judgment and denied ours. That's part of what's before this court, was that denial of our summary judgment, the granting of their summary judgment, appropriate, given the basis that the money had been paid, and what I'm suggesting to the court is that payment doesn't erase damages. It may moot a judgment if there is no other reason for entry of the judgment. Because a judgment is an adjudicatory act, and the court wouldn't take an adjudicatory act if there's no purpose. But there was a purpose at that point in time, and that was 93A at that point in time. And if we don't do that, if we allow later payments to eradicate breach of contract, how's that going to affect especially the small claimants? We've talked here, my client's damages were $360,000. Economic damages were the $360,000. Assume that the damages were $20,000.
But could you explain to me again, what are the components of that $360,000?
Remediation costs,
Okay, which were how much?
I believe about $220,000, $240,000.
All right.
The cost of Burns and Levinson on the,
In dealing with EPA?
yeah, dealing with the EPA, those are about $80,000 or $90,000. And then we contend that another portion of those damages are the claims management function that was thrust on in accumulating all of the documentation and such that rounded up to the 360.
Okay, and how much were you paid by Hanover?
We were paid $530 because of statutory interest.
Okay. You were paid $530,000 for what?
For
Very things?
those things plus the statutory interest from the point in time that those costs were incurred.
So it's a sort of moving, whenever they were, you figure the 12% from whatever the date was of.
Yes, I mean, we were asked to provide detailed information on damages, and we did. Very detailed information on damages. I've represented insurance companies for a number of years, and they require that type of information.
So you're suggesting that this $360,000 are the damages for 93A purposes. Even though they've been paid, they're the damages, right?
Correct,
Okay, and that should then either possibly be doubled or trebled.
correct.
Okay, so you've been paid the 360 and you're looking for more.
We're not just looking for the more, Your Honor. My client feels that he was wronged in this. He was put through a great deal. And the purposes of 93A is deterrence, okay? And if you look at the Hanover brief, they make one, I think, one of the more incredible statements there in their reply brief. They say, there is no obligation to provide a fair and objective determination of coverage.
Well,
Now,
how can that possibly be?
That concept we
That
have to
can't-
determine.
That can't possibly be the case.
That's their assertion.
Well, let me ask you this. Let's say Hanover did what we have suggested insurance companies do to avoid this problem, and that is, what if they had filed a declaratory judgment suit against you saying, we have no obligation to defend? And the court said, no, on balance, the complaint is broad enough, you do have an obligation to defend. 93A claim or no?
No, probably not, given my experience with doing that a number of times. The difference here is the multiple denials of the duty to defend, which were then, all of the pre-litigation denials for the duty to defend were abandoned by Hanover. They didn't even try to support them. You can look at the briefs.
And you sent a 93A letter before they had paid anything,
We didn't do a 93A letter, Your Honor, I don't believe,
Because it's a section
because it's under
under Section 11.
Section 11.
Okay, so you amended the complaint.
We did, and we did it, I think, in the right way. We
Yeah.
waited to make sure that we thought there was a good case for a 93A violation. Multiple reasons given to deny the coverage, abandoned. New reason put forth before Judge Garsh, called a tortured reading of the policy.
Okay, and then Judge Garsh would not allow the recovery of attorney's fees after that point in time because they were paying defense costs up to that point in time, after that point in time.
That may have been part of the reason. I really, quite frankly, never fully understood.
Are you looking for attorney's fees after the point in time in which they paid the
no.
$530,000?
No, we're not. Now, as part of 93A, we may do that if we prevail
For
on
multiple
93A.
damages, for
Correct,
multiple
correct.
damages.
Yes, on 93A. But that would, the only attorney's fees that we would be seeking going forward would be such attorney's fees as might be allowed if we're successful on 93A.
But you agree that that in terms of 93A, if Judge Veery's ruling sort of prevails, that you're going to have to prove as a factual matter that this was knowing or willful conduct on the part of Hanover.
Yes.
Otherwise, there's no point in going forward.
Correct. And my client understands that. He understands, I think, the risks and costs involved in doing that. And this is one of the reasons why I think it's important to allow those historic damages to be served, to put forward the deterrent value of 93A. Otherwise, insurance companies will be free at any time, as long as they beat the judgment, to tender what they owe.
Counsel, your time is up. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Aaron White. I'm here on behalf of Hanover Insurance Group. During argument, counsel did not address the principal issue here, and that is whether or not AutoFlat, for purposes of its 93A claim, has sustained actual damages. 93A is...
But
Yes.
just on that point, and I understand you say, no, they haven't, because you've paid and you paid with interest. But you paid after the litigation started. I mean, don't we usually look at what was the state of affairs before the litigation started?
Your Honor, if you look at the procedural history here starting with the judgment on the DJ, which occurred on...
We don't have a judgment in this case.
I
You
understand
agree with
that. It's a declaratory judgment, and I would make that distinction. But the court ruled on December 8th, 2009. Immediately thereafter, if you look at the record, my client contacted Attorney Jernberg and sought an accounting of damages. There's a letter in the record at page 168 of the appendix dated January 14th, 2010, wherein counsel indicates that he would provide my client a full accounting of his client's damages. Fast forward, the next interaction between the two is a motion to amend the complaint to add the 93A claim, and that's on March 3rd, 2010. The next day, or March 5th, 2010, the court allows that, and the amended complaint is docketed as filed. We still don't have an accounting of damage at that point. A month later, Hanover answers, and then a month after that, we get a final accounting. Hanover receives a final accounting, and...
Has Hanover to that point said that it would pay upon a complete and accurate accounting?
Your Honor, Hanover at that point didn't know what the accounting
Oh, I
would
understand
be.
it didn't know what the amount was, but did they in principle say that, following Judge Garsh's ruling on the motion for summary judgment establishing that you did have a duty to defend, upon receipt of a satisfactory accounting, Hanover will pay? Did they say anything like that then?
Your Honor, there's nothing in writing to that effect. There were conversations with counsel.
That may be, but there's nothing in the record that
That's
suggests
right.
that Hanover, in fact, committed to paying.
That's right, and Hanover did not answer its complaint by saying it would pay single damages as the complaint requires. However, at that point in time when it did answer, there was this process in place wherein Hanover was asking for an accounting so that it could evaluate what reasonable damages were, or what the damages were that flowed from the duty to defend decision. And that's
But why does that matter? If there's a duty to defend, there's a duty to defend regardless of the amount of damages, isn't it?
well, that's right. But the consequences that flow from the duty to defend are to pay or compensate the party for those defense costs, as well as the defense costs in establishing the duty to defend.
But if one could imagine exacerbated facts even beyond this. I mean, let's say this went on for 20 years, and you're not defending, you're not defending, you're not defending, and they incur enormous costs to DEP or EPA, and then you come in finally, and they bring a suit against you, and they say, and the judge says, yes, there was a duty to defend, and you say, oh, gee, how much did it cost you for these 10 years? I mean, at some point, somebody gets to say it was unfair or deceptive of you to read your insurance policy this way, and we get double or treble damages, don't you?
Your Honor, I disagree. What happens, as has happened in this case, is reasonable minds throughout the Commonwealth disagree all the time about the reading of a policy.
That may be, but that hasn't been adjudicated yet.
Well, the reading of the policy has been adjudicated on the duty to defend issue.
Right, but as to whether it violated 93A has not.
Well, true, but the penalties that typically follow from a duty to defend case are the penalties against the insurer for forcing the insured to bring the declaratory judgment action. That is the Gamache line of cases wherein if I'm insurer and my insured brings a DJ action and I fail, then I'm obligated not only to pay the defense costs in the underlying action, but I'm also obligated to pay that party's fees for bringing the DJ action, and that's what we did here.
Right.
And to clarify earlier, there was a question.
But you agree that if you had acted in bad faith with regard to the duty to defend, you may have to pay 93A damages for that bad faith. And that would be arguably double or treble the amount that they had paid for their defense costs.
What I would agree with, Your Honor, is that they would first have to establish the prima facie case
Yes,
under
they would.
93A, and they don't have damages, and we argued that to the lower court to support that case.
But does I guess the key issue,
actual
the key issue as far as I'm concerned is, does the grant of summary judgment on the duty to defend, do we treat that as a judgment with regard to 93A, for which they're entitled to double or treble damages?
So, Your Honor, there are no cases in the Commonwealth or outside of the Commonwealth cited by either party that support that premise. Judgment is defined by 54A as the act of a trial court finally adjudicating the rights of the parties.
That hasn't happened here.
And that hasn't happened here, as you pointed out to my brother.
So you're saying that, let's imagine the most evil insurance company ever, acting as badly as they can. You're saying as long as they pay the defense costs upon being found to have breached the duty to defend, they are immune from damages under 93A?
No, Your Honor, I'm not. I was alluding to the one penalty that existed for losing on that declaratory judgment action, and that's the Gamache line of exceptions. The second is the loss of use of the money. In this case, there's no doubt that Hanover paid both.
Okay, but you paid both. But
Sure.
I guess my question is, again, I'm sure you're a wonderful insurance company, but let's assume you were not. Let's assume you were the most evil of all, acting in the baddest of faith. As long as you did what you did according to your argument, there could be no double or treble damages.
As long as the insurance company is making the party whole, which is the requirement under all of the case law that's cited, and that is to provide them what they were owed under the contract, essentially to provide them with the benefit of the bargain. And then under 93A, the measure of damages, if they've done that, is the loss of use. That is the lost use of that money and the interest.
But what if through discovery they were able to show that there were some emails or correspondence, between the adjuster and the home office or whatever, that indicated that there was really an attempt by the insurance company to try to wear them down and not pay and not defend? They have $539,000 worth of damages in that case, don't they?
Your Honor, well, first of all, that doesn't exist in this case. But secondly,
Well,
they didn't have to
I'll grant
accept-
you that,
Yeah.
but if they could show that.
Sure. Knowing the law as it existed at the time that we're talking, when we argued this case at the Superior Court level, and it hasn't changed, by the way, but they didn't have to accept the settlement. They didn't have to accept the monies that we were offering. Hanover would do that at their peril because they may incur interest on that money in the future, but that was their option to do that. If they thought that there was a valid 93A claim that supported their claims, they didn't have to accept the payment.
Well, as
But
they
isn't
point
it-
out, that might have adverse consequences for them at the insurer's hands later.
Excuse me?
I said, as they point out in their papers, doing that would inevitably redound to their detriment.
Well, Your Honor, they point out that we could potentially argue that they had a duty to mitigate at that point,
But let's go back to Justice Spina's question. So, I mean, one of the things here is, let's say those emails show we're going to wear them down, and worst that happens is maybe they'll have the resources and the fortitude to bring a DJ action themselves. You didn't bring the DJ action saying we don't have any duty, that you made them do it. I mean, at some point, there is unfair conduct that it seems to me, even though you may have, while the litigation is pending, have tendered the money, they get a right to argue, yes, they tendered the money, but that is what we want to prove to you, Judge, was knowingly or willfully withheld from us, and we get to have it doubled. Why can't they do that?
Your Honor, they have to still establish
They have to establish
those
it. I understand.
damages. How do they establish the damages under the case law that exists and the statutory framework? They can either have a judgment on damages.
Because you
right
didn't
out of
pay
Section
until
11.
after that lawsuit started. That's how.
I'm sorry?
You did not pay until after the lawsuit started.
So what would be the damages in those circumstances? All the attorney's fees unpaid to date?
Well, that's a
As
good
of the
question,
time you
Your Honor.
paid?
It could either, it could be the attorney's fees, and they would seek to double or treble that, but that's not what they're trying to do here. They're seeking to double or treble the entire payment. The $360,000 is a combination of the underlying attorney's fees to defend themselves against the DEP action and the indemnity costs.
But the argument is that you could have limited yourself to single damages had you, for the $360,000, if you had tendered that with your answer to the 93A complaint.
I understand that argument, Your Honor, but the single damages component don't come into play in this case because
You're saying they have no damages because you paid them.
that's right. We're saying that they don't
At
have
the
single
time of the
damages. If
answer.
there is a judgment, they could get single damages. If there is not a judgment, then they get loss of use. We've paid both with interest here.
Have we ever said in any of our cases, or suggested in any of our cases, who should have the burden of bringing the declaratory judgment action, the insured or the insurer?
I think it's a mutual option for both parties. I haven't seen a distinction as to who has the obligation.
Who's in a better
to bring it,
position to
Who's in
do
the
it?
better position to bring it. Back to Justice Botsford's point, one issue that you address is Hanover sat there and didn't bring the declaratory judgment action. Well, that's because reasonable minds disagree about their coverage position. Hanover had counsel. They had counsel evaluate the coverage position, and they thought it was a good coverage position. The converse could be said to the fact that the Autoflat waited until the last minute to bring their declaratory judgment action in an attempt to prove that duty to defend.
Well, but the problem is that if reasonable minds may differ, that means that that everybody's taking a reasonable position, and shouldn't you be the one who's most likely to bear the burden of starting a declaratory judgment action on the duty to defend?
Well, Your Honor, I think that both parties have the option, and Hanover didn't know until they filed their action that they thought that their coverage position was any better than ours. We can look at the language of the policies as they did in Polaroid. People can differ over their points of view over the policies, but that's why the declaratory judgment statute 231A is there. It's to provide
Abandon those
relief.
initial positions, though?
Pardon me, Your Honor?
If they were reasonable, then I don't quite understand why you abandoned the same positions later that you now say were reasonable at the time.
Well, Your Honor,
Maybe they were, but isn't
yeah,
that
I
part of the
wouldn't
question?
characterize it as an abandonment of the coverage decision in the underlying case. It's a further look at the facts and the circumstances as they apply to the policy. And we're not here to. That's an issue that would be addressed if they were able to
Right.
step over the threshold and the necessary components of having either a judgment or having actual damages through loss of use. And they don't have either.
In Ameripride, they didn't have a judgment.
They did, Your Honor. And I meant to clarify that for you.
How
There
did-
was a jury verdict that.
The jury verdict, right?
Yes.
And as I understand it, the judge did a calculation based on the jury verdict, entered a judgment, there was a motion to correct the judgment. So they ultimately got a judgment. But just assume, isn't that right?
That's partially right, Your Honor. There was a judgment for the plaintiff, there was a judgment for the defendant.
Correct.
The defendant established that, I think the plaintiff the plaintiff established the defendant violated 93A, and then before they.
Actually, the other way
It's the
around.
other way
Yeah,
around, you're right. And then before they tacked on or doubled or trebled the damages, they did an account, after they doubled or trebled the damages, they cut out the recovery for the defendant.
Right, so I guess what I'm saying is, in the judgment for the defendant in this case, in that case, I mean.
In the Ameripride case.
Right, in the Ameripride case. There was a corrected judgment because the judge was persuaded by the motion for reconsideration, I should double first and then subtract, rather than subtract and then double. And I guess I don't, those events, that is, the overpayment, all that happened before any litigation in Ameripride. It was part of the facts. It didn't happen while the litigation was pending,
The
correct?
payments?
The stuff about the linens all happened.
Sure, of course, yes,
Right.
yes.
Here, you had no payment, you had the auto crushers, I'm getting them, I'm conflating it, auto flat car crushers, bringing the DJ action, among other things, and breach of contract, and then you had payments made well into that litigation. So one could argue that this is actually a stronger case to do the offset than Ameripride, couldn't you?
I don't believe that's the case, Your Honor. I think that the statute requires a loss of money or property. And in this case, they haven't sustained a loss of money or property.
But what if they, let's extend it out a little differently. Supposing instead of adding the 93A claim against Hanover when they did, they waited until the litigation ended, the environmental litigation ended, and paid out all the money and paid out all the, and defended themselves, and then brought a 93 action against Hanover.
Well, that's what they did, Your Honor.
Oh, okay.
So the DEP action was
Yeah,
concluded
yeah.
at that point, and that's,
Okay.
they had their full accounting of damages and they provided it to us. So that's what they did. And I'd like to leave the court with that, the statutory framework as well as the Clegg decision clearly state that the insurer is not to be penalized by making a coverage decision as it did. In addition, the statute doesn't punish settling insurers by placing the entire risk of the award at risk to 93A damages. Thank you for your time.
All right, thank you, counsel. We'll take our morning recess.